4 hours. I start talking to you. I think I'm just going to start reading it. It's Johnson versus United States 1 versus Johnson United States versus. What is your greatest threat to having reckless use of force or detention force, and then there's the use of violence?
I got a law review article that comments on it. I can already make it.
But that's something I mentioned.
Yeah, that's my long one. Yeah, you got 30 minutes. And that'll get you another.
Everybody was ready.
Okay.
Gotta get off the plane.
You get off the phone?
Yeah.
You got on the phone?
And then Veronica's somewhere. I think she's next to him because she's getting sound of it. And this is
Ready to New York now. Thank you.
Before the lunch break, we were talking about the state of Anthony Hill, later in this case, who was shot, and you had said that he had showed what you believed were signs of excited delirium. And I guess my question is there any evidence that you saw in the review of what you did that Mr. Hill was impervious to pain?
No.
Was there any evidence that you saw in your review of the evidence in this case that he had superhuman strength?
No.
And the opinions you are reaching, or what the information you're basing your opinions on, is the characterization of what this defendant said in his various statements, correct?
No, and the witnesses and their statements of his behaviors, Mr. Hill's behaviors.
The officer in this case, I think you noted in your report or during your testimony, acted, in your opinion, appropriately, that he was kind of cognizant of what was going on, he was using his faculties, he was using his instincts, and appropriately, took aim and shot Mr. Hill. That's your opinion.
I would add, and based on his training and experience.
And that following that, he also did what was appropriate. He went and got a first aid kit, he got gloves on, he attempted to tend to Mr. Hill and wanted to do whatever he had to do to do things the right way, or the process, correct?
That's correct.
And there's no information that you have that at some point he had a mental breakdown or lost his mind or anything, right?
Who's he?
The defendant, Officer Olson.
Not that I'm aware of.
Okay. And you're also aware from reviewing the evidence in this case that the first responder following Officer Olson on the scene was Officer Anderson, right?
That's correct.
And that Officer Anderson spoke to him, and in a report, Anderson stated that he asked Olson what happened, and Olson said that he was attacked by Mr. Hill, and Mr. Hill came up and pounded on him. Isn't that correct?
That's correct. That's his statement.
And so you'd agree, though, that that's not what happened, right?
Not that I'm aware of.
Right. That's not what any witness says happened.
That's correct.
Including the defendant.
Correct. There's a discrepancy there.
Well, discrepancy? Is that what you would call that?
I would say one person's trauma statements uttered within minutes of a traumatic situation, and I know how oftentimes that can be delivered to someone else. Officer Olson believed he was attacked, but I don't believe, I didn't see any evidence where he was struck or pushed or anything of that nature. So that's his belief, his statement, that he said he didn't say that, but Officer Anderson, so that's a discrepancy between those two officers.
And you've watched the video as well where it actually shows the two of them having a conversation and Officer Olson kind of acting out with his hands up. You've seen that video, right?
He had his hands up. Yes, I saw that.
Okay. And so that was just a discrepancy. Is that right?
Well, what I'm saying is that's Officer Olson's recollection within the manner of minutes versus what Officer Anderson testified to or reported to the SBI.
So,
GBI, excuse me.
All right, so it's clear then that there are times when Officer Olson's version of events is not based in reality.
I wouldn't agree with that.
Now, you'd agree that someone, just because they're running towards someone doesn't mean they're running at them to hurt them. They could just be running to them, right?
It's possible.
You know, like...
You got to give me more than just that.
Sure. Let me state that if someone is running to someone, if they're running to them, normally they slow down as they get to where they're trying to go, right?
Possible.
Okay. In this case, isn't that exactly what the witnesses say happened, other than Mr. Olson, that he slowed down as he got to the officer?
Well, I think that there's a discrepancy there, again, of what slow is. There's a continual advancement towards Officer Anderson,
Sure.
Olson.
But you'd agree his speed went from whatever speed it was, and obviously we'll agree to disagree, but to some lower speed. Is that fair to say?
Yeah, I don't know what the speed was.
Okay. And the fact that someone is running at them and slowing down as they arrive is not in and of itself a threat.
It could be.
Now, there are other things you agree. I know you said that you believe Officer Olson could shoot him based on the facts, but there are other things he could have done. You agree with that, right?
No, I don't agree with that.
He could not have done anything else, is what you're saying.
Correct.
Let me show you. It'll be, I don't know if that screen's still on. Is it on?
Yes, it is
All
on.
right. You've seen this before. This is the Defense Exhibit 2. Move it over a little. It's a map that kind of depicts where folks are. And you can see from it that Defense Exhibit 2 shows kind of where Officer Olson drove and then came around the building and then stopped somewhere where I'm pointing the pen. And that Anthony Hill was somewhere where I'm pointing the pen now, where it's marked Hill. And the witness Pedro is marked here. That's where Pedro was. And you've had access to this before today, correct?
Correct.
Because this was done as a part of his deposition, Pedro Castillo, right?
Correct.
All right. So, I'm pointing here where Mr. Hill is, where it says Hill with an X. When Hill is here, and the officer is in his car here, at that point, he's not a threat to the officer, is he?
Yes, he is.
From 150 feet away?
Sure, absolutely, yes. Because he started to run already.
We're not there yet. He was crouching down, wasn't he?
Not according to that diagram. That's not what I had. My impression of him was between the buildings. Crouching
and, I
down.
want to talk about that. In your report, you wrote that, and this is on page 2 in the second paragraph of section 10. Officer Olson responded to the apartment complex, and when he arrived, he observed Mr. Hill naked, crouched down, with his arms between his legs. Officer Olson turned the patrol car around in order to obtain the correct building number so that he could radio backup officers that he observed Mr. Hill and to inform them of the specific location in the complex. As Officer Olson turned the patrol car around, he observed Mr. Hill running towards the patrol car. Well, we all know that that's wrong, right? He didn't turn the car around, did he?
That's where I got the information from the statement in the grand jury.
And the statement from the grand jury is from Mr. Olson.
That's correct.
Right, so that information is wrong.
That's my impression of his testimony to the grand jury.
Okay. And you've had a chance to see this map. The defense entered Defense Exhibit 2 from witness Pedro Castillo that they deposed. That doesn't say anything like that. He drives around the building. That's not turning around, right?
My understanding from the grand jury testimony was that's what happened. So that's why I wrote it in the report.
But you could be wrong, right?
It could be.
But facts are important. Getting it right in this case, right?
And I do put, as all the evidence shows, where the patrol car did stop.
So, when he came around and back to Defense Exhibit 2, Hill is here where I'm pointing. At the point he started running, Officer Olson could have gotten his taser ready and fired at him, correct?
No.
So when he's right here where I'm pointing, he couldn't get ready to fire the taser?
No, I couldn't.
He's
in the car.
When he's right here where I'm pointing, he couldn't get ready and have the taser fire?
No, absolutely not.
And when he gets right here, further closer, he wouldn't have the taser ready to fire?
No.
And when he got right up on the police car, maybe 10 feet away, he wouldn't have had the opportunity to get the taser out and fire at him?
No, this was all a dynamic fluid type of situation.
You'd agree that Mr. Hill did not have superhuman strength, right?
I didn't see any.
And you'd agree that he didn't have the ability to appear and disappear in the course of his getting to the police car, right?
No, but there was a time period, a short time period, when Officer Olson did lose sight of him, and did lose sight of him as he was opening the door.
Well, you'd agree, wouldn't you, based on your training and what you train officers, that if you have a threat in front of you, it's a good idea to keep your eye on that threat, and there's a way to open your car door without having to look down, right?
It's possible, but it also could be snug. From what I read from the GBI's investigation of the report, that door had a problem opening. And a left-handed officer's trying to get the seatbelt off, that's going to cause a fraction or a second to try to get that door open. He had to try to get that door open twice. So he's looking down here, where can I open the door? How can I get this door open? So that's where, in his testimony, what I saw was he lost sight momentarily as he's opening the door. And prior to that, when he was circling around to the other end of the apartment complex.
Now, when Mr. Hill, I'm going back to Defense Exhibit 2, I'm pointing to the spot where it says he's there, is here, and Officer Olson is in the patrol car. At that point, Officer Olson could have gotten out and gotten his ass baton ready to strike Hill as he got closer, right?
No.
Well, when he was here, I'm just kind of pointing closer and closer to the officer. At all those times, he could have gotten his ass baton out and struck Mr. Hill when he ran at him, correct?
No, my impression was when Officer Olson stopped the patrol car, when he opened it and finally got out, Mr. Hill was already at the bumper. So there's not this segment that you're trying to portray here of integral times.
Okay, well I'll ask you a hypothetical, because I know that you're basing it on that fact pattern. What if, in the fact pattern I'm going to give you, Mr. Hill is where I'm pointing now, Officer Olson is in the patrol car where I'm pointing now, and then Officer Olson sees Hill run towards him, and doesn't lose sight of him. He can then get out of the car, have the ass baton, and then strike him, because you agree. Well, first, I want to compound the question. He could do that, couldn't he?
No.
All right. You agree ass baton is a close-quartered weapon. You don't use it from a distance, right?
That's correct, or backpedaling.
Right. You're not going to hurl the ass baton out of that something, correct?
Not normally, no.
Right. There may be a situation where you have to, but in a
There
normal situation, you're going to hold on to it, and you're going to use it the way it's supposed to be.
That's correct.
It's your opinion and your testimony here that that was just impossible for Officer Olson to do.
Correct.
And then the same question with Mr. Hill here on Defense Exhibit 2, Officer Olson here. At any point in the time that it took Hill to run to the front of the patrol car, Officer Olson could have taken his OC spray out, charged it appropriately, gotten it ready, and fired.
No, I don't agree with that.
Same reason? Now, you'd agree, though, that guns are not always the answer, right?
You have to narrow it down before that.
I'm
In a deadly force situation, they're always reasonable.
All right. But in a threat situation, I'm being careful with my words here, a threat situation, I didn't say a deadly threat, a threat situation, guns are not always the answer, are they?
I wouldn't agree with that, no.
Explain.
You may have limited reaction time. So you have to give me more than just a very general, ambiguous statement or comment.
Let me give you a hypothetical. I'm in the parking lot at the supermarket. I'm at my car. I carry a weapon. I'm authorized to. I have a permit here in Georgia. I carry a gun. The parking lot, about 150 feet away, I see a male. He's naked, and he starts running towards me at my car. And that's what he's doing. He's just running towards me. He's got nothing in his hands. He's got no weapons. He's not saying anything. He's not screaming. He's not making faces. He's just running. When he gets about 5 to 6 feet away, then I can just shoot him, right?
Possibly, yeah. Self-defense.
Thank you. Those are all. Can I add a fact to just a hypothetical you just given?
Yes.
I want you to assume that you're not just someone standing in a public parking lot, but that you're a police officer wearing a uniform. Okay?
Yes.
I want you to assume further that you can call out to the public supermarket, grocery store, based on a 911 call. This is known to you, that there are residents of the apartment who have locked their door, and the person is naked and climbing and jumping off of the balcony.
Yes.
Okay. I want you to further assume that I say that you're a police officer wearing a uniform, and that you're driving a marked patrol car. Okay?
Yes.
You're not just Pete Johnson eating his cupcakes out in the public parking lot, minding his own business. Okay?
Correct. Right.
I want you to further assume that when you, as the police car comes pulling up into the public parking lot, the person who is you previously seen naked crouched down in the parking lot, and is the subject of the 911 call, comes charging at you, sprinting at you.
Yes.
I want you to further assume that you take out a weapon as a show of force, as a show of control. Okay?
Yes.
I want you to further assume that you yell, "Stop! Stop!" That's your voice.
Yes.
The record should look like I just was speaking too loudly, probably. Here. And you didn't, and the naked person charging at you, running at you, did not stop.
Yes. I'm with you.
And when he's approximately somewhere that neighborhood of 3, 4, 5 feet, absolutely precise, would you be justified in shooting at that?
Absolutely.
Are those facts substantially more accurate than the rather trivial example which was just given to you by Mr. Johnson, someone minding his own business and talking to you cupcakes?
Yes.
Now, Mr. Johnson began his cross-examination with you asking you about what you'd read and referred specifically to a number of references in, I think, Castillo's deposition, correct?
Correct.
You, in fact, read the entire deposition, did you not?
Yes.
Of Mr. Castillo?
Yes.
And you also read the police statement, there was no deposition, but the police interview with Miguel Medina, correct?
Correct.
And you read the depositions, the other depositions you mentioned, Giselle, Flores, other written statements, some of which were not depositions, correct?
That's correct.
You read all of them?
Yes.
And the statement that you provided that we gave the prosecution to prepare for this, you refer, I'm sorry.
Yeah, I want to reject the commentary. You can just ask me.
You make the same commentary, but I'll sorry, I should have said that. I wasn't trying to I apologize. You based your report on all of those reports, correct?
Yes.
And there are some inconsistencies in the reports, is that correct?
Yes.
So, one person may say his hands were raised straight up in the air, one person may say his hands were raised off to the side, one person may say back. This is all over the course of 4 seconds, different observations from different points of view, correct?
That's correct.
Your job in preparing the report was not to be a fact finder, correct?
That's right.
You weren't in your report that you gave to me, which was then furnished to the state. Your report wasn't meant to suggest I believe some witnesses but not others. Is that correct?
That's correct.
Your report was essentially a summary that you used to advise everybody here, the court, prosecution, the defense, a basis for your opinion. All right?
That's correct.
Now, let me turn to the deposition of Mr. Castillo. You were asked specific questions about what he said, whether it was consistent with what you put in your report with regard to his hands. Let me begin. You don't need it in front of you. I'm just going to read to you, and he's got it, and read to you a few passages and see if this was part of what led you to write in your report what you wrote. Okay? If you recall, Mr. Goodham on page 19, line 9, he was questioned, was he running faster than John? Answer, a little faster. Was he sprinting? Answer, I saw him running. Go down a few lines. Line 20. Did Mr. Hill ever stop running? Answer, no, he didn't stop. Was that part of why you wrote in the report what you did that Mr.
Yes, I would agree with that.
Which question you would have. And turning to page 21, line 18. Did it appear like he was going to attack the police officer? Answer, if I was in his place, and I think the context is that he's referring to Mr. Olson, the words are, if I was in his place, I would have thought he would, do something to me. He could do something to me. Is that part of what led to you forming your opinion about what Mr. Castillo said and the confrontation that he had with Officer Olson?
Yes.
And then on page 22 up at the top, question. Did you mean that if you were in the police officer's place, you may have thought Mr. Hill was going to attack you? Objection, and then the answer, yes. If I was in the police place, I would have thought that he was coming towards me and do something to me. Is that correct?
Yes.
And is that what led you to believe, to put in your report what you did to Mr. Johnson was questioning you about?
Yes, it is.
Okay. And then on page 24, lines, including line 3 or 4, Mr. Castillo was asked, did he, according to the officer, did he move behind his car? Answer, yes, behind the car. He's referring to that point of the deposition of that. Is that correct?
Yes.
Right. And then, not to be too repetitive, he was asked on page 27, the witness testifies under oath, I was talking about Anthony when he was coming running. I thought he was going to do something to the policeman. Do you recall that?
Yes, I do.
And then finally, on page 36, line 18, the question to the witness was, now I understand earlier Mr. Hill never stopped running, but when he got closer to the police officer, did he slow down at all? Answer, no, he didn't stop. As the officer was stepping backwards, he continued running towards him. Was that Mr. Castillo's sworn testimony in deposition?
I recall that, yes.
And was that the basis for the report that Mr. Johnson said was inaccurate that you wrote?
Yes.
Now, did you also read the police report, the transcript that we provided to you of the oral statement, the recorded statement of what Mr. Medina said to the officer?
Yes, I recall that, yes.
And he was in the pickup truck behind,
Yes.
correct? And did that also form the basis of your information in your report?
Yes.
And did he say that Mr. Hill never put his hands straight up? Do you recall that?
I recall that, yes.
And his hands were out to the side as he approached Officer Olson.
Yes.
Mr. Johnson's questions to you as he goes through the progression from Mr. Hill being in a police car, Mr. Hill being in a crouching position, between buildings. You can see where the exit's here, right?
Yes.
Right about there. And I actually put my cell phone on and I timed how long it took Mr. Johnson to just describe each step along the way. Could he have taken out his aspartame? Could he have taken out his OC spray? Could he have taken out the taser? And it took Mr. Johnson about 4 minutes just to go through that line of questioning. How long was it between the time that Mr. Hill began sprinting, running fast, more than jogging, whichever description you want, and the time he gets to the police car? Was it 4 minutes?
No.
Did Mr. Olson have 4 minutes to decide, well, now I think I'll take out my aspartame, I can take it out from under its snapped belt, I can telescope it out. Did he have 4 minutes to make that decision?
No, he did not.
Did he have 3 minutes?
No.
Okay. And the time it took to get from over here, where Mr. Hill was, until he got to the front bumper of the car, did he have 3 or 4 minutes to take out his taser and ignite it, or whatever you do with the taser? That's not the right word, obviously. Engage it and fire it up and get it ready to go?
No, sir.
Did he have 3 minutes?
No, he did not.
4 minutes?
No.
2 minutes?
No.
How long did he have?
From the time he got out of the car, it was 3 seconds.
And in that 3 seconds, he yelled, "Stop, stop," pointed a weapon, and Mr. Hill didn't stop. Isn't that correct?
That's correct.
He continued to run according to the witnesses.
Yes.
Sit down. Any additional witnesses?
With that, that's right.
Statement.
No, nothing further. All right, exhibits in, I think we're all.
You're not. Okay, very well. Are y'all ready for the argument on this motion, or do you need a break to gather your notes before that?
I don't really need a break, nor do I need more than a couple minutes, unless you want to do an hour for a typical, 2 hours for a typical murder closing argument. But
Well, I'll give you whatever time both of you think you need.
I don't need much time.
Very well. Whenever you're ready.
If we have the, go further than last.
Absolutely.
You'll be the first half. Your Honor, I'm not going to take a lot of time. We've been here for 2 days. You're not sure you're going to need to go. I'm not going to. After Bob, you have, but I need to very much to you. Briefly, we're here in the immunity hearing. We have the burden of preponderance of the evidence. I don't think, as I said, that we have much disagreement about the law. We're dealing here with the right of an individual, whether he's wearing a uniform or not, to act in self-defense. And as we will discuss when it comes time to consider the demurs and in particular the supplemental demur that we filed in the state's response to that, we are not here to decide whether he complied with Cat Canyon's force policy. We are not here to decide whether he should have used an aspartame, or should have used OC spray, or should have engaged and complied with the use of force continuum. It's really a very simple question that
you're actually deciding it's the same in every self-defense murder. Factually, but legally the question is, you're an objectively reasonable person. Having said that, I should add that in the shoes of the officer. A little bit of a subjective component in there. But we're an objectively reasonable person. It's objectively reasonable to believe that he was facing serious bodily injury, threat of death, or the commission of a forcible felony. 16-321. I've been charged a million times, even in your short tenure as a Superior Court judge here. The standard has never changed. And significantly, for purposes of the supplemental the murder under 16-321C, it doesn't make a difference what policy DeKalb County has. It doesn't make a difference if DeKalb County said you have to stand on your head 3 times before you can defend yourself. It doesn't make a difference if DeKalb County says if it's a mentally ill person, you're not allowed to shoot. None of that makes a difference because it's simply not the law. Good policy, perhaps. Good training materials, perhaps. Perhaps that's the way we would like all policemen to act perfectly. That's not what we're dealing here in a criminal murder trial. What we're dealing with here is one question only. To keep an objectively reasonable person in the shoes of knowing what Officer Olson knows, and in his shoes, believed that he was facing imminent bodily injury, threat of death, or the commission of forcible felony. He has no duty to flee, 16-3-23-21. He has no duty to run behind the car. He has no duty to stay in his car or jump back in his car. Good policy maybe, in hindsight, you wouldn't have this tragedy, but it's not the law. It's not the law when you're facing a citizen state with a murder charge. We're not talking about police misconduct. We're not talking about taking his badge away. We're not talking about demoting him. We're talking about a citizen in the state of Georgia being charged with defensive murder. There's no doubt, from our point of view, that this case is tragic. There's no doubt. There's no heroes. We're not asking you to declare Robert Olson as a hero. We cannot lose sight of the one incontestable and uncontradicted legal question. Uncontradicted legal question and facts that when he's getting out of his car, he is confronted with serious bodily injury. He did not know at the time that Anthony Hill was a war hero. We don't contest that now. We don't contest that he had tragic events in his life. He served honorably in the Air Force. He came back and wasn't treated honorably by the VA. He had problems with medication. He had a loving mother who tried her best to care for him. He loved his mother back. None of that's known to Robert Olson. None of that's known to Robert Olson standing in the parking lot that day when he was confronted with Anthony Hill. We can't use hindsight. It is unfair. It is unfair for Robert Olson to say that shooting a war hero is not justified. Shooting someone who had mental illness is not justified. That's not the question in this case. You want to take his badge away, you want to have a civil service hearing about the use of force and training, that's fine. That's not what this case is about. It's no different, as Mr. Johnson would have you believe if it was you or me standing on the sidewalk. What is different, though, compared to what Mr. Johnson's last hypothetical was, Dr. Ross, is the notion that he's just out there minding his own business and someone was running by, as if it was, a tracking or something. Someone was running by and he decided to take out his own shooter. When Robert Olson was out there that day, he didn't know whether he was a war hero, whether he was a drug, whether he was a meth dealer. He didn't know any of those facts. Okay? And I know the prosecution's probably going to respond is, well, shouldn't he have tried to learn all those facts before he shot? Because then we wouldn't have to be here today. He didn't have the luxury of doing that. He didn't have the time. He wasn't given the opportunity. He wasn't given information ahead of time. There was nobody there who met him at the parking lot to say who Anthony Hill was. None of those facts were available to him. They want to second guess now and say, well, he shouldn't have gotten out of his car. He should have called the dispatcher. He should have called, who called 911? I need to know more facts here.
None of that's in the law. None of that's in the official code of Georgia where you have responsibility to do any of that. Good policy. Officer Webb wants to say, well, you should have found that more, call your supervisor or something. There's no law that says you have to do that. In the criminal code. Maybe good policy. Maybe they should train their officers better. Maybe the county's at fault here. For only giving you 1 hour of training on use of force with all of these various things that might happen. Olson didn't do anything criminal, but he drives out and I don't understand his last name is backing up or whatever, but and he pulls into the parking lot and slows down. And the outrageous notion that he is the aggressor in this case is hardly worth responding to. So I'm not responding to that. He does what any reasonable officer would do in that situation. He pulls up slowly, parks his car, he's not confrontational, he's not putting on his blue lights or sirens, he's not running to kill, he's not running up to him saying, I'm not going to shout at you, but he's not going to run and say, get on the ground, get on the ground, you know, cursing at him and doing what we see terrible TV shows that policemen do. He's just sitting in the police car, trying to figure out what to do. That's what Officer Olson does. He's really doing exactly what they tell him he should be doing as a good officer. He's trying to gauge the situation. He's sitting at the end of the parking lot there, looking ahead in his windshield to try to figure out what's going on. Not the slightest bit of aggressive behavior on his part. In contrast to this astonishing argument being made by the prosecution now that we should treat Robert Olson as the aggressor in this case for self-defense purposes. He sits in his patrol car for whatever, a second or two. Everything's happening in the amount of time it'll take me to finish this sentence. That's how long we've got to evaluate what happens once Hill starts running. He's in the car and suddenly Hill starts sprinting at him. He doesn't know what to do. He wouldn't know what to do if I started sprinting at the bench right now, I suppose. What's this lawyer doing? Yeah, now you got 4 seconds left to try to figure out what to do. And he decides he should get out of the car. I can't imagine anybody would say that's criminal behavior to get out of the car. For a policeman to say, and he's not thinking, he's just all instinct. It's all just instinct in a second. He says, I'm going to get out of the car and figure out what's going on. This guy's running at me. Hindsight is so easy. Back up the car. Lock the doors. We wouldn't be here today. I agree. There were all kinds of things he probably could have done, and we wouldn't be here today. Because it turns out that Hill was not going to stop him. He wasn't. We didn't know that. Olson doesn't know that. He just makes the decision to get out of the car as opposed to fleeing. Nobody called him. Giselle Torres didn't call him and say, it's a mental health problem. Even though I asked for the cops, he's not the doctor. It's a mental health problem. He's not injuring anybody. Olson doesn't know that. He gets a 911 call. He goes out there. He's told police are needed for a demented person. He doesn't know whether he's a resident. He doesn't know whether he's a trespasser. He doesn't know whether he's a drug dealer. He doesn't know any of those things. The prosecution says, well, therefore, it's murder because he didn't try to learn it. Our answer is, he's doing the best he can, with limited information. And when the rubber hits the road, 5 seconds left to start making decisions. Without any of the background information. He's the one who's got to make a 5-second decision. Okay? He didn't put himself in the situation where he only had 5 seconds to make a decision. He didn't rush up the transaction. He didn't put the stopwatch on and say, we got 5 seconds to bring this to a head. He wasn't running after Hill. He didn't even drive his car up to him. He stops the car. Now, to start the clock, you have 5 seconds to figure out what's going to happen now. He starts to get out of the car. They can make fun of him. They can ridicule him. You don't know how to get out of a car. He's wearing his belt. He's got his gear. He's got his seatbelt. Now you got 4 seconds left. He's a lefty. He's got his left. He's opening up the car door. It's not a big to do. But now we've got a second. You just lost another second. And he gets out of the car. Now we're down to 3 seconds. And now Hill has run so fast, according to every witness,
some of which you've gotten through hearsay, through the experts having read the depositions, and some from the witnesses themselves. We're now down to 3 seconds. Start your stopwatch. 3 seconds now to figure out what you're going to do with a guy naked in the middle of the afternoon when you've got a 911 call who's coming at you. And he makes a decision, Olson does, he's going to pull out his firearm. Okay? If he pulled out his aspeton, we don't know what would happen. Someone was going to be on the ground, that's for darn sure. Maybe it wouldn't be a murder case, but someone's going to, we don't know if you could even get it telescoped out in that amount of time. Okay? It's too late already for the ECD. It's too late for the taser. When he's in the front of your car, moving, running. I ask you to do one. To do anything methodical or thoughtful in 5 seconds. Prosecution asked all the other witnesses. Johnson, Mr. Prosser asking Giselle, Torres, and Mr. Steve, well, did he run on you? No. Well, okay. Did he challenge you? No. Did he threaten you? No. Well, good. I'm glad. I'm sure he was very pleasant to everybody that morning, and to his family as well. Well, none of those people are charged with the crime. Of course, nobody did anything in that situation. He ran on Olson. That's who he charged. That's who he challenged. And let me tell you one thing that Olson doesn't know. He doesn't know what Hill was doing earlier that day. He doesn't even know he lives there. He has no idea. Easiest thing in the world to sit here for 2 days and analyze this 5-second period or 6-second period and to use that kind of concept. That's not the luxury that Olson had. Mr. Johnson, when Clark Palmer objected to something about surveying the neighborhood, Mr. Johnson said, well, he should have surveyed the neighborhood, should have canvassed the residents to determine the threat level. What kind of nonsense is that? He responds to a 911 call, he goes out to the parking lot, he's supposed to survey the neighborhood? Like, how does he, what is that supposed to happen? Canvass the neighbors? I doubt there's any, you take
10 people and put them in a situation where they've got 3, 4, or 5 seconds to respond to an imminent threat, and they all react differently. And they all arguably are reasonable. If you've got a law clerk sitting here one night working on a brief, and the courtroom's empty, and you tell your law clerk, I want this report, not a brief, an order. I want this order done by the end of the day. And he or she is sitting here working by himself, writing an order. And suddenly the doors are flinging open, wherever it's 50 yards away, about 90, 50 yards. And someone comes running in naked. Right? There's nobody here. There's no other officers. There's no bailiffs. There's nobody in the audience. And someone comes running in to a courthouse where presumably there's no guns, except for the officers. What's the law clerk going to do? I bet every law clerk would do something different in that situation. Someone's going to run back into the jury room and try to see how fast they can get out of here, if they can do that. Someone else may say, whoa, what are you doing? I didn't do anything to you. Who are you? But if there was a weapon, someone's going to pull out a weapon and say, don't you dare get any closer to me. And if the person keeps running, there's going to be a shot that's fired. And all 3 of those reactions are reasonable to maintain. All 3 of those reactions are maintained. And you can come up with 7 other examples of what would happen when you think your life's in danger. And we can belittle Officer Olson and say you had all these other avenues. But he did what he thought he had to do for self-preservation at that point, and it was reasonable. It was a reasonable thing he did. When you law clerks may decide just to fight him. You got a big law clerk, you got a big former football player. He may say, well, come on, let's have at it, whoever it is who's running in. That might be a reasonable response too. Got a cup of coffee. Someone may throw the coffee at the person. But there was a gun there, and you thought you were about to be hurt, seriously injured. If you thought a forcible felony under the Georgia Code 1613, if you thought a forcible felony, aggravated assault was about to occur, you are allowed, in the laws of this state, to shoot to defend yourself. Robert Olson did not know anything about Mr. Hill. He didn't have the opportunity. He wasn't given the information by anybody there. I dare say if it turned out if he was some crackhead selling crack in the neighborhood, was high on drugs himself, everybody would be giving Robert Olson the medal right now. So many other drugs. He didn't know who this person was. As much as the prosecution would want to say, he should have known. That's the whole problem. He didn't have the opportunity. He wasn't given the chance to know. We would ask you to find, based on the evidence you've occurred here, and under 16.321, 16.321C, 16.323.1, the duty retreat law, that we have carried our burden of showing by preponderance of the evidence that he acted reasonably, and that it is a reasonable use of deadly force in response to what he perceived to be imminent bodily injury, threat of death, imminent commission of forcible felony.
Thank you. Mr. Cross.
Thank you. I'm struck sitting there listening to Mr. Samuel's hypotheticals that he gave before, and I'm as astounded to hearing him say that as I was after hearing his experts talk about how easily you can decide to kill someone, apparently. The analogy he gave, the hypothetical that Mr. Samuel just gave you, was someone sitting in this courtroom, someone runs in and runs at them. They're allowed to shoot and kill that person, according to Mr. Samuel. That is not the law. That can't be where we are right now. They say stop, and if the person doesn't stop, they're allowed to kill them. What if they're dead? What if it's a 17-year-old autistic kid? What if it's a veteran who is suffering from mental illness
and identifies uniforms as help because he served time in the military. What if he's told people at the scene, help, I need help? What if 911 was called so he would get help? What if when the uniform arrives and he sees it, he runs to it for help? You can shoot and kill him according to Mr. Samuels. You can shoot and kill him according to those so-called experts that came to this court today. That is wrong. That is not the law. And for the court to find that to be reasonable would send a terrible message to anybody that's someone that suffers from mental illness in their family. Don't call the police. The one thing that the defense motion did in this courtroom in the last 2 days is proof to this court that there is absolutely no reason that Anthony Hill should not be alive with his family today. That's what this motion did, and that's it. In their own argument, the defense brought up all the different conflicts in the evidence. Hands up, hands down, running, sprinting, why he was called, what he did when he got there. That alone, Judge, keeps you from saying, I find by crimes of the evidence that it was self-defense. I will not let this go to the citizens of this community. I will take it out of their hands. That alone, you could hang your hat. Just way, way more than that. If you look at the witnesses they called, this is their motion. Pedro Castillo, he hurt no one. He was hurting no one. He asked for help. Their witness said, and they can ignore it or not mention it, and their experts cannot include it in their reports all they want, but their witness said he slowed to a walk, just like you do when you run to someone and when you reach them. That's what happened in this case. Their witness, Ms. Torres, said, I was not afraid of him. He was not scared. She's not a trained officer with a gun. I called to get him help. I was afraid he was going to get hurt on the balcony or someone else was going to hurt him. Their expert, I don't even know if he can comment on Mr. Murphy. They called him an expert. I'm not sure what case he was actually working on. I don't think it was this one. It must have been one out of Kansas. He was completely ridiculous, and he got almost every aspect of what actually happened wrong. I'm an expert not to rely on him at all. And then the officer, the former officer, if you had just his testimony, think about what he said. He didn't have a weapon. He was not armed. And he said very clearly, I don't really have any idea what he was going to do. Not, he was going to kill me. Not, he was going to seriously injure me. I don't really have any idea what he was going to do. I don't have an idea if when he got to me, he was going to hug me because he saw me in uniform and he needed help. I don't have an idea if he was going to run past me. I don't have an idea if he was going to drop down on his knees and thank me for showing up. His own words demand this goes to a jury. And I shot him from 5 or 6 feet away. He couldn't touch me. He couldn't reach me. He couldn't attempt to harm me. I shot him that far away, Judge. And he was unarmed. And then Officer Anderson's testimony. He told me he was pounding on him. Now, he has selective amnesia. He forgot that. I would ask you, Judge, to take a look at that and realize that makes Robert Olson not credible. And everything from their experts, the flow came from Robert Olson, someone who, at the very scene, lied and gave a reason, gave an excuse for why he took someone's life that wasn't true. He didn't say, I thought he had a weapon. He didn't say, I thought he might bump into me. He said he was pounding on him. Then Officer Anderson said, yeah, I was waiting for more. I said, what do you mean? Well, what were you waiting for? Well, he had just killed a guy. I was waiting for him to say he had a weapon, that he was armed. Because obviously, Officer Anderson, in any reasonable person's mind, it takes more than someone running at someone, and according to Officer Anderson, even someone pounding on him to kill him. It's not reasonable. You know, Instructor Webb told you that this was not appropriate. This was not reasonable. This is not how he was trained. And that there were lots of things he could have done. And then the last expert, Judge, I want to touch on him, talked a lot about excited delirium. I find it interesting that Mr. Samuels gets up and says, well, it doesn't matter that he's a police officer. I don't know why we're talking about use of force. when they brought two use of force experts into this courtroom. And so we spent hours and hours with their use of force experts. And then we rebutted it with ours. And then they brought up excited delirium. They can't have it both ways, Judge. It's either the law applies to a regular person and to an officer the same. And excited delirium, that defense is ridiculous. And honestly, it's offensive. Think about the assumptions that Officer Olson would have had to make at the time to determine that he was suffering from excited delirium. He was a guess. And we don't even know that's what he assumed. But if he assumed that based on the experts, that was a guess. He killed someone based on a guess. That was wrong. That he had no evidence for. It's not reasonable. I've got just a few cases for the court, and I've got copies for the defense and for Your Honor. Just as pull 3, and I'll talk about it briefly, just to give the court an idea of the kind of cases that have been reviewed, in which the trial court has said that has denied immunity motions. I'll talk first about Cifuentes versus the state, and that's 293 Georgia 441. It's a 2013 case. That's a gang case out of Cobb, Your Honor. And you had, the gist of it is you had two opposing gangs. There were Norteños and Sureños. And earlier in the day, they had actually had a confrontation. There had actually been an attack on one of the members. Later in the day, the member sees the opposing gang again, and one of those gang members has a weapon. And he fires into a group of people, killing someone. At an immunity hearing, they said, look, you know, there had been this hostile environment. These guys were going at it. They were rival gangs. One was armed. The guy that shot saw the gun. And he wasn't pointing the gun at anyone, but he saw it. So that's enough to give him self-defense. The court said, no, it's not, and it was upheld. Think about all the things in that case that are not here. Prior tensions, a prior attack, a weapon. And the court said that was not reasonable. State v. Thompson, you've got somebody driving a stolen car, it's a hit and run, and then they take off. And the officer testified he believed that this person was armed and dangerous and was a threat to others, as he was a fleeing felon. The court said that's not enough. That's not reasonable. Think about all the things you have there that you don't have here. Robert Olson testified. I don't really know what crime he was committing. Stop and think about that. I don't really know what crime he was committing. The experts gave you a couple of misdemeanors, and that was enough for him to kill Anthony Hill. And then Anthony versus the state. In that case, you got kind of a love triangle situation. The person that was killed in the case had actually threatened the person that shot him. He'd actually hit the person that shot him before he did. You had a history of violence between the two. And even then, the court said, no, that's not enough. He wasn't armed. And the guy testified, yeah, I lost my temper. He hit me, and I pulled out a gun and shot him. There was actual physical violence in that case. And the trial court said, no, that's not reasonable. That's going to a jury. And the appellate courts upheld that. We're nowhere near the neighborhood of these cases. And so based not only on the tragic facts of this case, but on the law, you're required to, and we respectfully request that the court not take this case out of the hands of the community of DeKalb County, but instead to deny the defense motion. Thank you.
Anything else?
No, Your Honor, we appreciate the opportunity to do with the transcript that's done, to citations to the record and cite some cases, but frankly, the number of cases where the trial court finds that the case should go to the jury, that then go to the appellate court that reverses versus non-existent. So you just don't get those cases that they just below. So I can't cite cases that vary in this contract. But we do have a lot of cases that deal with the civil rights context, and I know Mr. Carter disagrees that that has any relevance at all. And I think he's wrong, but I'd like to submit some of those cases in a short brief more importantly, cite to the record for
How much time do you think you need after you get this final transfer?
assuming the transfer doesn't have like tomorrow or something like that, yeah, a few weeks would be fine. 14 days if we could have that after the transfer is delivered.
The state like the same?
Well, I guess it does. I mean, obviously, we obviously don't want any more delay in the case, and we actually were ready for our cases, but I found that's fine. Of course, I mean,
Why don't we make it 2 weeks and not 3? And if you get to the end of the second week, if there's some issue, you need more time, you can let me know. I'll ask Mr. Cross to make that transcript our highest priority. All right, let's take a brief break and then come back, and I'll hear from you all on the other motion. All right.
give over? What's coming up?
I hear. I feel like yours is better somehow.
Hey, Ryan,
Is yours split?
you put that second card in already, didn't you? So I'm getting ready to erase it.
I do hear the keyboard. But yours doesn't. I think yours sounds better. I don't know what to do.
Go with it.
I can't use this sound.
Well, you would like to see it?
Hey, Bruce.
I was looking at you know, something to go out.
It's angry. I can't tell. But I'm angry.
Yeah. So I wonder if Robin idling. Next one. So the only thing I heard is and that one's actually so I'm not sure that was yeah, that's right. I didn't really hear the keys. Yeah. You did.
He wants to transfer it. He's got to wait for the transfer for this case, and the judge can take 2 weeks to see those. So we want to make a decision on after at least 2 weeks on the case. I'd say definitely at least 2 weeks. So what are these other motions? Yeah, so I don't think it's going to be all right.
Keep everybody in line. So you broke it? Once or that's all I was wanting to broke it. This is raggedy, man.
No.
We're on 4 o'clock. I think at 4 o'clock.
text me down tomorrow. Who's cool with tomorrow? I'm tired.
Your Honor, we have filed, in essence, two separate general demurrers, though I characterize one as the general demurrer challenging counts 1 and 2 of the indictment, and the second one is the supplemental demurrer, really entirely separate. The first general demurrer is based, in essence, on a series of United States Supreme Court cases and cases from appellate courts around the country, which have reviewed a statute which is in no way similar to the felony murder statute, other than the fact that it involves the use of predicate offenses in order to trigger the greater offense. And in particular, we're dealing primarily, though not exclusively, with the Armed Career Criminal Act, which is 18 U.S.C. Section 924E. But there are other statutes which involve this kind of predicate offense, such as 18 U.S.C. Section 924C, which is the firearm, use of a firearm during the crime of violence. And what those federal cases, what the federal statutes provide in essence is 924E, the Armed Career Criminal Act says, if you have a certain number of prior convictions for a crime of violence, your sentence is automatically higher. It's 15 years for the most part. That's the Armed Career Criminal Act. 924C, the use of a possession of a firearm during a crime of violence, also defines crime of violence. So there has to be a crime of violence and you possess a firearm. So there were a series of cases beginning, probably 15 years ago, in which the United States Supreme Court tried to figure out, it may seem silly to the public, but what exactly is a crime of violence? It triggers the possession of a firearm, for example, going from 2 or 3 year sentence all the way up to 15. What is it that these predicate offenses must involve in order to satisfy? Both statutes, 924E and 924C, give a definition of what is a crime of violence. They're different definitions. 924E generally is described as having 3 different definitions. One is called the enumerated offenses. These are crimes of violence, A, B, C, D, E, and the statute lists them. That's one definition. The second definition is what's called the elements clause, where what the statute says is these offenses, and then number 2, or an offense that has certain elements as part of the crime. And then there was, but no longer, something called the residual clause. And the residual clause in 924E had very vague language about any other crime that poses a serious threat of injury. And so that's 924E. 924C has a similar kind of set of definitions of what crime of violence can justify a 924C conviction, which is a mandatory 5 years, or depending on the type of weapon used, 7 years, and if it's discharged, even more. And again, the courts are struggling with 924C to figure out what exactly is a crime of violence that would, excuse the pun, trigger a 924C conviction. So that's kind of the background of the general demurrer we filed with regard to counts 1 and 2 of the indictment, which is the felony murder statute. Because the felony murder statute, like 924E, like 924C, requires that there be a crime that is an element of the offense with which we are charged. Okay? Both 1 and 2 are felony murder counts. Count 1 is felony murder with the underlying crime being aggravated assault. Count 2 is felony murder with the underlying felony being violation of the oath of office. So you can kind of see the parallel with 924C and 924E and 924C. Got my numbers mixed up. In that we have this vague definition of what qualifies as a predicate. And what made it particularly vague was the Georgia State Supreme Court decision in Ford v. State. Of course, is kind of the essence of what we're arguing about here. Ford involved a felony murder prosecution in which the underlying felony was possession of a weapon by a convicted felon. And the question was, because the felony murder statute says if you commit a felony and then without any intent whatsoever someone dies as a proximate cause of the commission of the felony, then you're guilty of murder. The simple classic example: you're robbing a convenience store, you have a shotgun, you have no intention of shooting the clerk or anybody else in the store, and the gun goes off and kills somebody. Okay? You're guilty of felony murder even if you didn't want to shoot the gun. If you just dropped it and the gun went off and killed the next person in line, you're guilty of felony murder because you were committing a felony, armed robbery, and as a proximate cause someone died. No intent needed. Same with drug dealing. You're involved in a drug deal, nobody's supposed to die, we don't want anybody to die, but someone gets shot. Felony murder. There have been cases where a doctor prescribes medicine, one of the cases in the briefing. A doctor overprescribes medicine. He's not being a doctor, he's being a drug dealer in essence. And the patient dies. The felony of distributing drugs leads to a death, felony murder. No intent to kill. Doctor wasn't intending to kill anybody. But he distributes drugs as a drug dealer as opposed to a doctor. Someone dies, felony murder. So up until the decision in Ford v. State, the law was, in essence, any felony at all. You commit a felony, if someone dies, you're guilty of murder, life sentence. In Ford, the defendant was charged with what we sometimes refer to as a status offense, meaning possession of a gun by a convicted felon. He had that status. He was a convicted felon. He possessed the firearm. And the question was, when someone died as a result of his possession of the weapon, he shot the weapon. He just didn't intend to kill anybody. If someone dies, is that enough to be felony murder? And in a somewhat surprising decision, at least to those of us who were around then, the Supreme Court said no. Even though that's a felony, and even though the code specifically says any felony, there's nothing ambiguous about it. The Supreme Court ruled, I think it was Willis Hunt, ruled that that's not the kind of felony the legislature was thinking about. Simple status of possession of a firearm. And that there has to be something more about the felony that qualifies it
as a available or eligible predicate for felony murder case. And what Ford said, as I said in the brief that we filed here, is that the offense must be a dangerous or life-threatening felony. Okay, that's the language in Ford v. State, 262 Georgia, 602. But then it added another line. Don't want to go too far without adding another line. Or, I want to get the language right, it also says, or was committed in such a way that it was violent, that it was dangerous. Let me get the exact line. Which by the attendant circumstances creates a foreseeable risk of death. Okay, so it could be a status offense or something that's not dangerous per se, if by the attendant circumstances that felony created a foreseeable risk of death. So we have challenged counts 1 and count 2. Count 1 we are challenging on the same basis as the Supreme Court decisions in United States versus Johnson, and then the recent case just 2 weeks ago in the deportation case. I need to get you the Sessions decision. I noted in the state's brief they cite Ovalis, which was vacated last week. There's such turmoil over these definitions in the federal courts. Ovalis was a case that held that 924C wasn't void for vagueness. And then last week, the 11th Circuit, I don't call it unanimously, but they vacated the decision, and it's now going to go on bank. So all of this is kind of in turmoil in the federal courts, because there they said even the definition of a violent crime under 924C is arguably vague in light of the Supreme Court decision 2 or 3 weeks ago. So, count 1 is aggravated assault, and I'm really just going to rely on my brief if I can for that. To be perfectly honest with you, it's a much more difficult argument to make. I did the best I could in the brief, and I don't want to waste your time with regard to the aggravated assault predicate. I think it's a valid point, but there's a lot of law against me on that one, no doubt about that. Count 2, though, I think is substantially different, because in count 2, the underlying felony is clearly not a violent offense. No doubt about that. I don't think the state would seriously argue that violating your oath of office is a violent crime. There's a million ways you can violate your oath of office, and the worst that could happen is you get an administrative sanction. So they can't go with the clause in Ford that says it has to be violent per se, dangerous or violent per se. Instead, they have to go with that second clause, which is the attendant circumstances, the method by which you committed the crime of violating your oath of office. Satisfies the second element of Ford. It created a foreseeable risk of death. And let me add to my argument here, if I may, and I'll do a supplemental quick memo. I don't think we argued sufficiently in the general demur itself. What I think is important about Ford is I don't think you can take the language in Ford and say it doesn't matter at all what the underlying felony is. I don't think that's what then Justice Willis Hunt, now Judge Hunt, meant when he said the attendant circumstances have to be a foreseeable risk of death. I think what he was saying is the method by which you committed the crime, was dangerous. Violating your oath of office is never dangerous. It just can't be. It's inconceivable that someone who violates an oath, like perjury, like making a false statement, is doing something that's dangerous. It's illegal. It's a felony. But the mere act of violating an oath, which is what perjury is after all, is not dangerous ever. It never is. What the state is saying here is, obviously violating the oath wasn't dangerous. It was shooting someone that was dangerous. But that's count 1. That's the aggravated assault. And what makes it particularly difficult in this case for the state to succeed in their argument is they said in count 2 that violating the oath of office was the violation of the use of force policy. In other words, you used excessive force. Well, of course, that's nothing different than aggravated assault. It's the exact same crime as the crime alleged in count 1. And just violating your oath didn't kill anybody. Violating your oath was not the proximate cause. It was the shooting was the proximate cause. And you can't take a violating an oath of office and say the violation of your oath of office was shooting someone. Shooting someone is pulling a gun out and pulling the trigger, not violating your oath or committing perjury or lying to a police officer. If you lie to a police officer about shooting someone, you're lying to the police officer who hasn't killed someone. Now, I did make somewhat of a facetious argument in my brief that you could imagine a case where perjury actually leads to a death. I mean, you can imagine such a situation, right? A witness is on the stand in a death penalty case and intentionally tells a lie implicating the defendant. And you could go through the steps and say, had you not lied, the defendant wouldn't have been convicted and wouldn't have been executed. So your lie led to the execution of the defendant. But that's not what we're talking about here. And that's clearly ridiculous anyways. That wouldn't be felony murder. No court would uphold a felony murder conviction under that scenario. And yet that's in essence what the state is saying. If you do something violating a public administration law, perjury, false statements, violating an oath, and someone dies, it's the proximate cause. What they're saying in that count of the indictment is not that you violated your oath of office and therefore someone died. What they're saying is you shot someone and someone died, which is count 1. So we have, not just as I say in my general demurrer duplicity argument, we have a multiplicity argument. It's the same thing as being alleged in both counts 1 and count 2. It is our contention in the brief, in the general demurrer, that the violation of an oath of office, and I'll just be as clear as I can be about this, can never serve, never, as a predicate felony for felony murder. I can't conceive of a situation where violating your oath is a dangerous felony, any more than committing perjury is ever a dangerous felony. You go to prison, there's all kinds of consequences. I'm not justifying it, I'm not saying it's okay, but it's not a predicate for a murder prosecution. Okay? So, and I just don't feel like I need to read my brief to you. You can understand my argument. That's my argument, is that an oath of office violation cannot, under Ford, be a violent felony. And the method of committing the offense doesn't talk about something like perjury, false statements, violating your oath. The method of committing the offense must be the method of actually engaging in the criminal conduct, the method of engaging in the criminal conduct. If somehow you could violate your oath by doing something, I just can't conceive of what it means, how you would violate an oath in a dangerous way. Scream, yell, rip up the paper in such a way, somehow you violate your oath in a dangerous manner. What they're saying is that the underlying conduct was dangerous, not the violation of the oath. The violation of the oath isn't dangerous. Nobody can get hurt by violating an oath. People get hurt by being shot. And that's not what the felony murder statute was designed to deal with, a situation of someone doing a completely innocent, non-lethal offense, just like Ford. And if all the state ever has to prove is that you committed a crime and someone died, why wasn't Ford convicted? He shot the darn gun. Who could possibly say that in Ford it wasn't, the attendant circumstances weren't dangerous? He shot the gun, someone died. And Willis Hunt said, well, that's not a dangerous felony. And apparently the attendant circumstances weren't dangerous. If that's true, how could violating an oath, perjury, false statements, any public administration crime, be considered to be a categorical dangerous felony that supports a felony murder statute? So I don't want to belittle any arguments we made in here, and I don't mean to minimize any of them. But the essence of our argument is essentially the same. If you read Johnson, you read the Sessions case from a couple weeks ago, I'll send you that site or send you the case. It's the one where Justice Gorsuch joined the four liberals, and there was big to do about that in finding the deportation statute unconstitutional. And Ovalis, I don't know whether the government knows or not, the prosecution knows or not, was vacated last week. Obviously, it was long after they filed their brief. In our demur, in paragraph 5, we've also challenged the sufficiency of the allegations in the case, which is a more traditional kind of demur. They just haven't set forth the facts that would justify the use of the Ford, the extra clause that it's a violent felony. They just cite violating your oath of office, and they don't say, and the attendant circumstances were such that it was dangerous per se. And under Jackson v. State, this Georgia Supreme Court decision from last year, I think it's Justice Namias' decision, 301 Georgia 137, it has to have that kind of allegation. An indictment can't just cite a code section anymore. That's the Jackson case decided unanimously last year, and incidentally, Judge Newkirk relied on it 2 weeks ago in a case throwing out all the one count of the Waffle House case, because the indictment just didn't allege all the facts that were needed to sustain a conviction. So that's on page 20. Well, my pages may be off, but it's Roman numeral 5 of our brief. We've also challenged, with regard to count 2, that it's duplicitous. I've always enjoyed using that word when I describe an indictment, but it suffers from the vice of duplicity, I think is the other way to phrase it, in that it charges 2 entirely separate crimes. Not 2 methods of committing a crime, but 2 entirely separate crimes in one count. And that you can't do. And the state's response is, well, it's just alternatives. Well, these aren't alternative methods. These are 2 entirely separate crimes. They allege in count 4 that he violated 17420B, which is one crime, and he violated section 4-6 of the use of force policy. Well, it is the use of force policy, 4-6. And the problem you have with that is, how are you going to assure unanimity? You could have half the jurors saying it's a 17420 violation, and half the jurors saying it's a use of force violation, and you don't have a unanimous verdict because you only have one count. And so we've cited a bunch of cases in our general demur that you can't charge 2 entirely separate crimes, not different methods. You can do that if in fact you don't need unanimity, but you can't charge 2 entirely separate crimes where you would need unanimity in order to have a verdict that would sustain a conviction. So we think that count 4 suffers from the vice of duplicity as well. If you allow me not to just keep reviewing everything in the brief, I'll move on to the supplemental brief, which is somewhere here. So here's the situation with the supplemental demur. You don't need any federal precedent to understand what is a very simple concept, statute, which is 16321C, OCGA 16321C. 16321C says, well, I'll back up a little bit. 16321 is the general self-defense statute. Okay, we've been talking about it for 2 days now. Person is justified in using force which is intended or likely to cause death or great bodily harm only if he or she reasonably believes that such force is necessary to prevent death or great bodily injury to himself or herself or a third person, or to prevent the commission of a forcible felony. I think we all agree on that definition. And what the legislature did a number of years ago, probably in response to Heller and cases like that, Second Amendment type of issues, added 16321C. And what 16321C says is
any rule, regulation, or policy of any agency of the state, or any ordinance, resolution, rule, regulation, or policy of any county, municipality, or other political subdivision of the state which is in conflict with this code section is null, void, and of no force and effect. That's what 16.321C says. Somewhat similarly, though somewhat different, is 17.4. 20B, which deals specifically with a similar statute, but deals more with unlawful force to perform a felony arrest. And what the statute there says is I didn't highlight it, but it's essentially the same thing. No statute can be passed that overrides the use of self-defense or use of force in a felony arrest. So it is our position, and I don't, to be fair to the state, I don't understand their position, or maybe not to be fair to the state, that 16.321C in essence is saying that the DeKalb County use of force policy is exactly what it says it is. It is a departmental rule. It is an administrative departmental rule whose force and effect is limited to administrative proceedings. And that's why I asked Webb this morning, isn't it correct that this policy is completely irrelevant to any criminal or civil proceeding? Because that's what it says. I'm not using the exact quote, but the use of force policy says it right on page 1. This document has zero force and effect in a criminal or civil case. That's prosecution's exhibit number 16, I think. And the reason they wrote that is because of 16.321C, which says you're not allowed to have any rule or regulation which is in any way different. It can't deviate at all from 16.321A, which is the right of self-defense. And that's why Officer Olson, if he's in fear of serious bodily injury, death, or forcible felony, can use deadly force. It doesn't matter what DeKalb County says. It doesn't matter what their use of force policy says. They can say anything they want. And it's just absolutely null and void. So we filed a demur saying it can't possibly be the predicate for a felony murder conviction. Because what they're saying in count 2 is you violated your oath of office, step 1. Step 2, the method by which you violated your oath of office was violating the use of force policy. Okay, that's step 2. Step 3, someone died as a result of your violation of that policy. Step 4, felony murder. You get a life sentence. There's nothing confusing about that analysis. If you violate the use of force policy, okay, and someone dies, you go to prison for life. Despite the fact that 16.321C says that the use of force policy is null and void to the extent that it differs in any way from self-defense. What's the point of having, why are we even going to be mentioning the use of force policy if there's even one comma that's out of place? If there's even one semicolon that changes the meaning of what is permitted in self-defense, it's null and void.
Well, I understand your argument.
Good, thank you.
I note that in your brief, you cite the statutes, you don't cite any law.
Yeah.
Where any law.
Yeah, there's a case called
Georgia, if there's a corollary in other states or federal law.
There's a case called Allen versus City of Atlanta, which I have the citation for. And there's another one. Allen is 235 Georgia Appeals 516, the 1998 decision. There was another case involving school, somewhere. I'll get you these citations. But there are few and far between. There's only 2 that I saw. I mean, I put 16.321C into the computer and only 2 cases came out. Allen is essentially on point. It's not a murder case,
These are civil cases in which, the court was asked to decide whether, I can't remember all the facts, but they said you can't have a policy, a school board policy. One of them involves zero tolerance for a student, and the student was sanctioned. And the defendant, very inventive lawyer, Clayton County, Henry County, somewhere down there as I remember, said, you can't have a policy that says zero tolerance for a student. That's inconsistent with the self-defense. Self-defense says you're allowed to hit someone or whatever it was in that case. And the school board said, oh, come on, this is a school policy, no hitting on school grounds. And the defendant said, you can't have a policy like that. 16321C says my student had the right to defend him or herself. Whatever, and I don't remember the facts, but that's the point. And what? The case then goes to the Supreme Court, and they don't even address that issue. They rule something else on the facts. They didn't reverse the Court of Appeals on that issue, but the Court of Appeals decision dealt with that. Allen is another case that is to say, nobody doubts this is the law. Even the state doesn't question that this is the law. That the use of force policy cannot govern the decision. You will never instruct the jury on the use of force policy. It's not the law. And I could have gone through the use of force policy and said, look at all the ways in which it differs. It's just endless. The continuum and the this and the that, and you exhaust your steps. None of that's self-defense law. None of it is. The jury shouldn't even be told about that stuff. And Ms. Carson, I just can't seem to get on the same page here. And to me, this is no different than challenging the constitutionality of a statute, which you can do in a demur. You can say, you've charged me with A, B, and C. Well, C is not a crime. It's not allowed to be a crime. It violates the First Amendment. It violates the Second Amendment. C's got all kinds of problems with it. You can't convict me of C. You've charged me with possessing a gun. Well, DeKalb County is not allowed to have a law that says I can't own a gun. Heller says so. You've charged me with speaking in a public square. Well, I got a First Amendment right to speak in it. We do that all the time in demurs. Right? We say the allegation violates some other superior law, usually the Constitution, right? Here we're like one step below. We're having a regulation that violates a statute, but it's the exact same method of analysis, I'd suggest, is that we are challenging the state's right to use the use of force as the predicate for a felony murder prosecution, especially since they haven't even outlined the facts, which is the Jackson argument from our first brief. They didn't even outline the facts that you violated, but they specifically, the indictment says you violated 4-6 of the use of force policy, which 16321C says is invalid, null, and void. How could that not be right? And the state says it's a speaking objection. It's not a speaking objection. I'm looking at the code sections. I haven't cited a single fact about this case in my demur. Not one. Their indictment says 4-6 is what you violated. And 16321C says 4-6 is invalid. And they say that I've done a speaking demur. I haven't cited a single fact. And then they say, well, this isn't going to be right, apparently, until we proffer, our self-defense case at trial. I suppose we could do that. We're going to get halfway through trial, and then we're going to have to dismiss count 2 because this is a self-defense case. I'm sure you're going to be shocked when you find out halfway through trial that our defense is self-defense here. And at what point during the trial are we going to say, this is a self-defense case? It's like the old Chandler rule we used to have. You make a proffer that this is a self-defense case, and it opens the door to all kinds of things. If the state wants to wait until the middle of trial and then discover, to their shock, that our defense is self-defense, and then agree, you're right, 4-6 goes out the window. Shouldn't have been mentioned in opening statement. Shouldn't have been mentioned at all during the trial. Needs to be redacted from the indictment that you read to the jury. I can't understand the logic of what they're claiming. I keep saying this, and there's nobody in this courtroom who knows more about the law than sitting at adverse counsel table here, but I don't get it. And usually we at least understand each other when we disagree, but we're just not on the same wavelength on this particular issue. I think that a demur can challenge the validity of an indictment which alleges something that is not a crime. And that's what we're doing in our supplemental demur. We are challenging 4-6 as a predicate for count 2 of the indictment. 4-6 is, in the language of 1621C, null, void, and of no force and effect. How could it possibly be the predicate? You can't violate an oath of office. You can't commit that crime by violating 4-6. It's null, void, and of no force and effect. The legislature couldn't have been more clear in 16.321C. Couldn't have been more clear in saying that anything, any policy that keeps using the word any policy, any regulation, any ordinance of any political subdivision, any county, any municipality, nothing is allowed to be enacted in this state that contradicts 16.321A, the self-defense statute. So that's our argument on the supplemental demur. We think count 2 needs to be vacated for both reasons, both the general demur and the special demur, for the more than one reason in the general demur, and for the same reason with regard to the special demur. Count 1, I'm not waiving that argument. I think the statute is equally void. Well, not equally, that's an overstatement. It's also void based on the Johnson line of decisions in the Supreme Court that even aggravated assault is not a sufficient predicate for felony murder. Believe me, I learned that 2 weeks ago. You know, if it's an aggravated assault without an intent to kill, there are aggravated assaults that are not violent. We're charged with aggravated assault, and that's the predicate felony. I don't want to get into the count 1 argument, frankly, but it's in our general demur, and we believe that the felony murder statute itself is unconstitutional because of the failure to specify what is an eligible felony, as opposed to relying on then Justice Willis Hunt saying, here's the new definition that we, the Supreme Court of Georgia, are going to decree is the new definition of what is an eligible felony, despite the legislature never having done that. Not easy task for you to find that the Georgia Supreme Court acted ultra vires, but in essence, that's our argument with regard to count 1 as well.
Cross, let me start by asking you if you could. I saw your response to the supplemental, and you raised some procedural defenses. I don't know if you get to the substance of their argument. Let's say hypothetically, I'm not persuaded by your procedural arguments 1 and 2. Again, only hypothetically. But what's your response to their substantive argument in their supplemental, if I get there?
There's no conflict. There's no conflict between thus 17.321C. Do you have a copy of that provision in front of you? Okay. There's no. I'm optimistic that the court would procedurally find with me that this is an improper speaking demur and we don't get there. But if we do, I agree that self-defense trumps. The jury's going to be charged that self-defense, if presuming the defendant can present sufficient evidence to get the charge, let's presume that for the purposes of argument, presuming that means it's a speaking objection or a speaking demur to have to presume that fact, but assume that he does. The jury's going to be charged that self-defense, as it would apply to anyone, not an officer, self-defense, as it applies to any citizen of the state, is a defense to count 1, count 2, count 3, and count 4. The jury could find, I don't believe they will, but they could, the jury could find that the defendant violated his oath of office in the manner in which it's charged, that he shot the unarmed Anthony Hill in violation of the code section and or the policy, but that he was justified in doing so. He meets the requirement for affirmative self-defense. And if he did that, if the jury found that, he'd be not guilty of the crime. He would not, could not, if he had a valid self-defense claim, be found guilty of the violation of the oath of office or the felony murder predicated on it if the jury finds he was self-defense. There is no conflict. All the reference to the use of force policy does is put the defendant on notice as to how the specific manner the shooting of Anthony Hill was in violation of his oath of office. That's all it does. It's a notice. It's not the substance of the charge. The substance of the charge is he violated his oath by shooting Anthony Hill in a manner that, in this way, was in violation of his oath, but he still has the same self-defense claim that anybody else would have. The C portion of the statute saying nothing can be in conflict with it. I agree. I couldn't charge him with the violation of the oath in that he shot Anthony Hill in violation of the policy and take away his right to claim self-defense. That's what subsection C is guarding against. That's what the school board policy case that Mr. Samuels was speaking about, Allen, does. The thrust of that argument, the fact of that in Jackson last year, Jackson said, listen, you always got to be able to act in self-defense. If you're at school, if you're a police officer, trained and obligated to follow the policy, all that's true. But before you can be found guilty of a crime, or in Jackson, a school violation, you have to be given the opportunity, the same opportunity as anybody else, to convince the fact finder that you were justified in doing it. Justification, self-defense, is a crime, or is an affirmative self-defense, or it's affirmative defense to almost any crime, and this isn't excluded. So that's my response to that. Mr. Samuel wasn't able to articulate or to provide to the court any law or legal authority from this state or any other where a charge in this manner, citing a policy just to put someone on notice, trumps self-defense, because I don't think that's true. That's not what the state's position is. He gets a self-defense charge to count 2 and count 4. So the jury can't find him guilty of those counts if, in fact, he is acting in self-defense. And if that's true, there is no conflict.
All right. Thank you. Sorry to...
No, I appreciate... No, I appreciate any direction from the court about what might be helpful or what might not. As I said, I won't belabor the speaking objection part. I do have, in addition to the cases I cited in the state's response, I do have another case, State versus Givens, Givens, 211 Georgia Appeal 71. It's a 1993 decision that I approached. I have a copy from Mr. Samuel as well. And the same portions are highlighted in all of them. And I think this was all spelled out pretty clearly. Again, I'll address any concern of the court, but as soon as you have to assume that there's enough evidence to get to the jury to support a self-defense charge, that's when it becomes a speaking demur. If you have to assume that there's going to be that evidence and there's the potential conflict, I don't think it's a conflict, that's how Mr. Samuels describes it. If you have to assume there'll be enough evidence to do it, to present the issue, then you've gone outside the 4 corners of the indictment, and that's what you can't do. And that's the Givens case, and that's the other cases cited. You can't go outside the terms of the charge as it's written to find a defect based on the anticipated evidence in the case. That's the state's, I think that...
Procedurally, what would we do? How would that transpire? If as Mr. Samuels suggested, the moment we start the trial, there'll be arguments.
And that might be true. It might be a directed verdict situation. It's just not a proper demur. It's just not the vehicle by which he can argue anything based on the anticipated evidence at trial. We all, after sitting here for 2 days, can anticipate what the defense may be, but the defense may change. And not in this case, it doesn't seem likely that that's possible, but that's the reason why the demur is based just on the allegations that are contained in the indictment. The defense isn't saying that the use of force policy is unconstitutional. The supplemental demur isn't directing this court or asking this court to find that the violation of the oath of office as a statute is unconstitutional. Those kinds of things are a demur. The defense position isn't that, well, it doesn't state a crime, they missed an element of the offense, or I'm not on notice about what I'm supposed to be charged with here, what I have to defend against, and what would protect me from double jeopardy down the road. That's a proper demur. But saying that my anticipated defense presents an issue that might be in conflict with another section of the law, that's just not a demur. That's not an appropriate means of quashing it. That's a fact issue. That's a sufficiency of the evidence issue. It's just not a demurrer. The other the primary demurrer, if there's any other question about that, I'd be happy to address it. I appreciate that the court felt that the issue on the initial general demurrer was well briefed, so I don't intend to go through all of the allegations. I'll respond briefly to what Mr. Samuel said this afternoon. I do, however, have to put on the record that the state does object to any expansion of the demurrer here in court this afternoon. A demurrer is very particular how you complete a demurrer and what's appropriate to do it. The timing of it is very specific. It needs to be in writing. There can be no, that again is a speaking demurrer. There can be no expansion of the written demurrer absent the court's specific approval to do that. So insofar as the argument this afternoon went outside the allegations in the written demurrer, the state just puts on notice that, put it on the record that we object to that. Felony murder statute is not unconstitutional. And it's not unconstitutional for any of the reasons that were advanced by the defense this afternoon. Appreciate that Mr. Samuel was candid enough to acknowledge that while he's asking this court to overrule Ford and Shivers and Chance and his progeny, that's not the position that the court can be in this afternoon. That the felony murder statute, the statute as it's written, 1651 statute as it's written says any felony can serve as the predicate felony for a felony murder count. That's what the statute says. Ford and the subsequent cases say that a felony that is dangerous per se or by its circumstances, one of those two things, purport to kind of extend the common law of what it was at the time that it was enacted. Justice Namias's concurrence that's cited in the state's brief in Shivers, S-H-I-V-E-R-S versus the state, kind of takes you how Justice Namias doesn't believe that was necessarily the decision he would have made at that time, but for reasons of stare decisis, Ford has settled law, Chance came later, that's the state of the law in Georgia, and it doesn't look like that's going to change anytime soon. So any felony can serve as a predicate for a felony murder count, including aggravated assault, violation of oath of office, perjury. Any felony can serve as a predicate felony for felony murder if it's dangerous per se, or if it, by its circumstances, is dangerous. It creates a foreseeable risk of injury. Aggravated assault as category, that's a dangerous felony. Violation of the oath of office as it is charged in this case, shooting of an unarmed man, that is dangerous by its circumstances, creates a foreseeable risk of death. That is sufficient to serve as a predicate felony for a felony murder count if the jury finds the proximate cause. We're not limited, I'm afraid, by Mr. Samuel's imagination as to what can serve the circumstances that might present themselves that would establish the proximate cause of any particular felony serving as a basis for a predicate, the predicate for a felony murder count. The jury, State versus the Jackson that's cited in the state's brief, State versus Jackson, it's the jury's determination about whether something can serve as a proximate cause, whether the violation of oath of office, in this case, shooting of an unarmed man, can serve as a predicate felony for the felony murder. That's a jury question. Every day, that's a jury question. Maybe the defense has an argument that the violation of oath of office in this case didn't cause the death of Anthony Hill. That might be their argument. I don't think it's a very good one, but they can make it. Jury could find it, and that's all. But it's a jury question, not a pleading problem. And by presenting this motion as a demurrer to the court, they're saying it's a pleading problem. There's no support for that. Johnson does, well, let me stick with Georgia law first. Felony murder statute for decades has been held as constitutional. It's not unconstitutionally vague. There's no defect, no constitutional defect that's been identified. Under Georgia law, there's no merit to the motion. The federal case law, the Johnson case and subsequent to it, that provides no support There has been no court in any jurisdiction in any state that I'm aware of or has been brought to the court's attention by the defense that applies Johnson, very specific to the residual clause of the Career Criminal Act. Nothing has been brought to this court's attention or that I'm aware of that takes the reasoning of that language and applies it to a statute like 1651. There isn't any court anywhere who's applied the logic of Johnson outside the specific statute for which it has applied, the Supreme Court addressed to. There have been attempts to analogize it, none successful that I'm aware of, certainly none based or translate to the felony murder statute similarly worded to the one we have in Georgia. There's just no analogy there. I appreciate Mr. Samuel's candor that I think he started his argument in saying it's in no way similar. You got to squint really hard to make the parallel between the language. And I think we've cited cases. It's true that it is in flux. That if we were here because the defendant was charged with any of the sections of the Career Criminal Act, I'd be in trouble. I'd be asking the court to maybe hold off until things got resolved because there is such flux in that area right now. But that's not where we are. This defendant's charged with felony murder. This defendant's charged with aggravated assault. This defendant's charged with violation of his oath of office. And none of those statutes, none of those elements of those offenses, none of the crimes at issue in this case are affected by the Johnson decision. So again, I'm happy to address any of those issues, but believe that the motion is properly denied there. Mr. Samuels might enjoy saying the word duplicitous, but I don't think he recognizes the legal meaning as to what duplicitous means. And I say that with affection for Mr. Samuel. The count charged in the alternative, I think that's where he was basing or directing his attention to the word duplicitous too. It is charged in the alternative. It's not two different crimes. That's what duplicitous means. Duplicitous is when you have elements of one crime and you combine them in the same count improperly with elements of another crime. And then that it's a Frankenstein crime. It's not a sufficiently worded, proper notice to the defendant way to plead an allegation. Counts in the alternative are something different. The state can charge in the alternative all day long. It's a stylistic reference in the indictment. The Lumpkin case that the state cited in its brief, we could have charged a single felony murder count, for example. A single felony murder count that put the defendant on notice that the predicate felonies were either aggravated assault and or violation of the oath of office. Could have put them both in there to serve as a predicate, and that's the example in Lumpkin. You can do that. That's not duplicitous. That's charging in the alternative, and it's appropriate. The state chose not to do that for the felony murder counts that way, but did choose to include alternative methods of committing count 4 in the indictment, and that's perfectly appropriate. So again, I'm happy to address any issue or concern of the court. That's the state's argument this afternoon. We ask that both motions, the general demurrer and the supplemental demurrer, be overruled. Thank you.
Ron, I want to use the section citation. It's 2018 Westlaw 1800371, April 17th, 2018. I continue to disagree, obviously, with the prosecution with regard to what is alleged in count 4. It specifically says, the method by which he violated those oaths of office was by using deadly force upon the unarmed person of Anthony Hill by shooting him with a firearm, in violation of the DeKalb County Police Department's use of force policy. Containing 4-6. They're alleging that's how he committed the crime. He violated the use of force policy. I don't know how it could be any clearer what they're alleging. And that's not a violation of your oath of office. It's a violation of use of force policy. It's not. So I don't understand their right. I continue to not understand the state's response to the supplemental demurrer. Other than that,
I know y'all wanted to do some additional briefing on the mediation. Any desire to do so as to this?
Not from the statement.
I don't particularly see the need to file any additional brief. I can use citations to the Allen and let it bring to you.
Very well.
I would suggest that you can do all the orders on the same day. We made this argument to you about a year and a half ago. Whatever orders you enter, if they all get done on the same day, it's conceivable that we still see a certificate. We can do them at different times, you end up with different time limits. That happened with the grand jury. Remember we talked about that, but I would ask you to at least consider however many orders that they all be entered on the same day, so we could talk to you about a certificate if needed.
Right. Well, unless the statements we heard, I think that makes sense. We'll note that request with receipts. Also, as far as briefing on the immunity motion, I think we talked about just 2 weeks after you get the final transcript from this crime. It occurs to me, though, it might make more sense to have the defense do something, the state respond to it, and the defense is the movement against the final word. So why don't we do, and I just want to keep things moving as quickly as we can, if possible, with 10 days, 7 days, and 3 days be enough time, or do you need more time than that?
We were talking, it just kind of depends on when we get the transcript.
Well, I'm assuming
Frankly, yeah.
the clock starts once you get the transcript. So 10 days after you get the transcript, you do a brief. 7 days after they get your brief, they respond, and then 3 more days you reply. And the answer could be no. If the answer is no, what's your counter proposal?
I think we'd like to say yes, and as you said before, if we get the transcript and we realize, 10 days for whatever reason, we're not going to be able to come back to the court and say, hey, there's been some conflict that has caused us to not be able to meet your deadline. But 10 days ought to be sufficient.
Okay, well, let's plan on that then.
Can we ask the court order to just a guess? Are we talking later this week? Are we talking about the middle of June?
You think end of this month would be feasible? Okay. Sounds like 2.5 to 3 weeks.
We're fine.
All right. Okay, thanks everyone.
Thank you, Your Honor.
Thank you, Judge.
Yeah.